My stepbrother Devon called me 3 weeks after my father's funeral and said there was a deed. He said my father had signed the house over to him 2 years before he died because Devon had been the one living there and taking care of things, and because my father had decided it was the right thing to do. He said it was already recorded with the Lucas County recorder and his attorney had confirmed it was valid. He said he was telling me as a courtesy. I said I would like to see it. He said it was in the public record and I could look it up myself. That evening, I went to the Lucas County recorder portal and I found the deed. It was there, a warranty deed, recorded 23 months before my father died. My father as grantor, Devon as grantee. The property on Geneva Avenue in Toledo that my father had owned for 19 years. I read it carefully. I am a nurse practitioner. I want to describe what reading a deed the way a nurse practitioner reads a medical record actually looks like. It means starting at the top and reading every section in order without skipping anything because you do not know yet which piece of information is going to be the relevant one. A medical record has sections: the chief complaint, the history, the physical examination, the assessment, the plan. A deed has sections too: the parties, the consideration, the property description, the covenants, and the acknowledgment. I read all of them. The parties section said my father as grantor and Devon as grantee. The property description matched the Geneva Avenue address. The covenants were standard warranty deed language. Then I reached the acknowledgment. The acknowledgment had a notary name and a date and a commission number. I wrote them down. Then I went to the Ohio Secretary of State website. I searched the name Harold Fenwick. The database returned a result. I read the commission dates. Expiration: 18 months before the acknowledgment date. I sat with this for a moment. Then I called Josephine. I had read the document carefully. I had verified what it contained. The answer had been there the whole time. I had only needed to read all the way through and to check what I found. I also want to say something about why I had driven to the library rather than searching the portal from home that same afternoon. I drive past the Toledo Library on my way to my parents' neighborhood, and I had been on the road when Devon called and I had pulled over and had the conversation in a parking lot. When it ended, I had been closer to the library than to home, and I had thought about going to the house first, but I had decided the public records question was the first question to answer and that I could answer it right then. The library has public computer terminals with internet access. I sat at one of the terminals and I searched the Lucas County Auditor portal for the parcel number. Then I went to the recorder. Then I searched the Secretary of State. All of this on library computers within an hour of the call. The resources were there, and I had used them. Every public library in Ohio has internet access. Every county auditor and recorder portal is free and requires no login. The Ohio Secretary of State Notary database is free and requires no login. The entire verification chain is accessible to anyone with internet access and the knowledge to search the right systems. I had the knowledge because I am a careful reader who had looked up what each section of the deed meant. Anyone can acquire this knowledge in about an hour of reading. The tools are free and available. Use them. Been in clinical practice for 17 years, and I understand the importance of reading documents carefully and verifying what they contain before acting on them. I read the deed from the first line to the signature block. I read the acknowledgment section. The acknowledgment section is the part of a deed where a notary public certifies that they witnessed the grantor's signature. The deed had an acknowledgment section. It was signed by a notary named Harold Fenwick. The acknowledgment was dated the same date as the deed, 23 months before my father died. I noted the notary name and the date. Then I went to the Ohio Secretary of State website. The Ohio Secretary of State maintains a public database of notary public commissions. You can search it by name. I searched Harold Fenwick. The database returned a record for Harold Fenwick. It showed the dates of his notary commission. His commission had expired. The expiration date was 18 months before the deed was signed and acknowledged. Harold Fenwick had not been a commissioned notary in Ohio on the date he signed the acknowledgment on my father's deed. His commission had been expired for 18 months. A person whose notary commission has expired is not a notary public in Ohio. They cannot perform notarial acts. A deed acknowledgment performed by someone who is not a commissioned notary is not a valid acknowledgment. A deed without a valid acknowledgment is not properly executed under Ohio law. Before I go on, if this story, I want to say something about the Ohio Secretary of State Notary Commission database and about what makes it such a powerful verification tool. Ohio has approximately 100,000 active notary commissions at any given time. The Secretary of State issues and maintains records for all of them. The database is publicly searchable on the Secretary of State website by notary name, county, or commission number. Each entry shows the notary's full name, their county of residence, and the start and expiration dates of their commission. Ohio notary commissions run for 5 years. When a commission expires, the person is no longer authorized to perform notarial acts in Ohio. They may renew their commission, in which case a new entry appears in the database with a new expiration date. The gap between an expired commission and a renewal, if one exists, is visible in the records. Harold Fenwick's commission had expired and had not been renewed. His most recent entry in the database showed an expiration date 18 months before the acknowledgment on my father's deed. There was no subsequent renewal. On the date he had signed that acknowledgment, Harold Fenwick had not been a notary in Ohio for a year and a half. The database had said so from the day the commission expired. The information had been there for 23 months waiting to be found. I had found it in about 2 minutes. 2 minutes, 2 databases, 1 comparison. The deed was void. I also want to explain how the acknowledgment section of the deed and the Secretary of State database entry interact as evidence. The acknowledgment on the deed shows what the person who signed it claimed about themselves, their name, their commission number, and often their stated expiration date. Harold Fenwick had signed the acknowledgment and had printed his name and commission number in the acknowledgment block. The commission number was a specific number issued by the Secretary of State. When I searched the Secretary of State database for Harold Fenwick, the database returned his record matched to the same commission number. The record showed his actual expiration date. The expiration date on the deed acknowledgment and the expiration date in the Secretary of State record did not match. The date on the deed showed a later date than the actual expiration date in the Secretary of State system, which means the date on the deed was wrong. The Secretary of State database is the authoritative record of commission dates. It is the record the state maintains. It is not subject to alteration by a notary who wants to appear to be current when they are not. Harold Fenwick had written a commission expiration date on the acknowledgment that did not match what the Secretary of State showed as his actual expiration date. The Secretary of State record was the truth. The truth showed the commission had ended. The acknowledgment was defective. The deed was void. The 2 records together told the complete story. Each record alone was not enough. Both together were conclusive. Connects with something real in your life. Please take a moment to like and subscribe, but only if you genuinely feel it. Drop a comment and tell me where you are watching from and what time it is there. I read every single one. My name is Renata. I am 45 years old. And this is the story of how a notary commission expiration date, which is a public record in Ohio searchable through the Ohio Secretary of State Notary Commission database, established that the acknowledgment on my father's deed was performed by someone whose commission had been expired for 18 months. And what happened when an attorney named Josephine Adeyemi put that commission record and that deed in front of the Lucas County Common Pleas Court? Now let me tell you about my father and about the house on Geneva Avenue. My father's name was Walter. He died at 74 of cardiac disease that had been managed for 6 years. He had lived in Toledo his entire adult life and had been in the house on Geneva Avenue since 2004 when he had purchased it after his divorce from my mother. The house was a brick ranch on the east side of Toledo in a neighborhood where the streets were straight and the houses were well maintained, and the neighbors had been in their houses long enough to know each other. My father had been a machinist for 30 years at a manufacturing plant in Toledo, and he had retired at 66 and had occupied his retirement with fishing on the Maumee River and with his garden and with the specific quiet life of a person who had decided what mattered and was spending his remaining years on it. Devon was my stepbrother. His mother had married my father when Devon was 12 and I was 14, a marriage that had lasted 9 years. Devon had stayed in touch with my father after the divorce. He had moved back to Toledo 7 years before my father died and had been in the area and had been available in the geographic sense that I, living in Cleveland, had not been. My father had a will. He had and I want to say something about my father and about the quality of his relationship with Devon and about whether I believe my father had known what Devon was arranging. My father was a careful man. He had worked for the city for 26 years and he had kept his records correctly, and he had not been a person who made significant decisions casually or without consideration. He had made a will. He had reviewed it with his attorney. He had expressed his intention clearly in a document that he had confirmed was current 2 months after the date on the deed. The will left the house to me. These facts do not coexist easily with a genuine decision to give Devon the house 2 months earlier. My belief, and I want to be clear that it is a belief and not a verified fact, is that my father had not known what he was signing when he signed the deed, or had signed something that was described to him differently than it was, or had not signed it at all. I do not know which of these is true. The defective notary acknowledgment made the legal resolution independent of this question. The deed was void because the acknowledgment was defective, not because of what my father had or had not signed. But the will reviewed 2 months after the deed said what my father's stated intention was at that time. His stated intention was that the house came to me. The legal outcome matched it. I also want to say something about Devon and about the conversation in the hallway after the hearing and what I have thought about since. Devon said Dad would have wanted me to have it. He said it with the specific conviction of someone who believes what they are saying. I think he did believe it. I think Devon had been the one who was there for 4 years and who had understood that presence to have meaning in my father's decision about the house. And he may have been right that my father had wanted to acknowledge his presence in some way. But my father had had an attorney. He had had the opportunity to make any change he wanted to make through a valid instrument. He had not made the change. He had reviewed his will and confirmed it. The will said the house came to me. Whether Devon had arranged the deed himself or had been assisted by someone else or had genuinely believed my father had intended it, the legal result was the same. The deed was defective and the will controlled. I do not know what Devon believes now. I know that we have not spoken since the hallway. I know that the house is mine and that the garden my father kept is still producing. I know that the will said what he wanted and that the court confirmed it. Whatever Devon believed, the document said something different. The documents were the evidence. The documents controlled. The records held what mattered. They always hold what matters. They held this attorney in Toledo named Charles Park prepare it 4 years before he died, and the will had been reviewed and confirmed as current 2 years before his death, at approximately the same time as the deed was allegedly executed. The will left the house to me. Charles had told me this when I called him the week after the funeral. I told him about Devon call and about the deed. He said he would need to see the deed, and he wanted me to research the notary. He said notary commission records were public through the Secretary of State. He said to look it up before we spoke again. I looked it up that evening. When I called Charles the next morning with what I had found about Harold Fenwick Commission, he referred me to a litigator. He recommended Josephine Adeyemi, who had been practicing civil and property litigation in Toledo for 16 years. I called Josephine that afternoon. I described the deed, the recording date, the notary name, and what I had found in the Secretary of State database. She said send me the deed and the Secretary of State commission record. I sent both by email within the hour. She called me back in 90 minutes. She said the commission had been expired for 18 months on the date of the acknowledgment. She said the acknowledgment is defective. She said a defective acknowledgment renders the deed improperly executed under Ohio law. She said a deed not properly executed cannot be validly recorded. She said the recording itself does not cure the defect. She said we will file a motion to void the recording and a petition to quiet title in Lucas County. She filed the petition in Lucas County Common Pleas Court within the week. She submitted the deed with its execution date and the acknowledgment bearing Harold Fenwick's signature and notary stamp. She submitted the Ohio Secretary of State commission record for Harold Fenwick showing his commission expiration date 18 months before the deed execution date. She submitted my father will, which had been admitted to probate, leaving the house to me. She submitted a sworn statement from Charles Park confirming the will was genuine and current and that he had met with my father at approximately the same time the deed was purportedly executed. She submitted my sworn statement describing my search of the Secretary of State database and the finding of the expired commission. Under Ohio Revised Code, a deed conveying real property must be acknowledged before a notary public or other authorized officer. The acknowledgment is the formal certification that the grantor appeared before the officer and acknowledged that they signed the deed. Ohio requires that notary publics hold a valid commission issued by the Ohio Secretary of State. When a commission expires, the person is no longer a commissioned notary and is no longer authorized to perform notarial acts. An acknowledgment performed by a person whose commission has expired is not a valid notarial act. A deed with an invalid acknowledgment has not been properly executed. The recording of a defective deed does not make it valid. Devon attorney filed a response arguing, "I want to say something about Charles Park, my father's estate attorney, and about what the will review meeting had been like and what it told him about my father's state of mind at the time." Charles had been preparing wills and trusts in Toledo for 20 years, and he had met with my father annually to review the will and confirm that it reflected my father's current intentions. The meeting 2 months after the deed date had been a routine annual review. My father had come in alone. He had been, by Charles's account, fully present and engaged and clear about his wishes. He had read through the will with Charles, and he had confirmed each provision. He had specifically confirmed the disposition of the real property, which was the house on Geneva Avenue. He had said yes when Charles had asked whether this provision still reflected his wishes. He had said that Renata should have the house. He had said this 2 months after the date on the deed that claimed he had given Devon the house. This was not a legal argument. The defective acknowledgment was the legal argument. But the timeline between the deed and the will review told a story about what my father had understood his situation to be. He had understood that the house was his to give and that he was giving it to me. 2 months after the alleged transfer, he had not believed the transfer had happened, because it had not happened. The deed was void. The will said what he had meant. The court confirmed both. I also want to say something about what Charles Park had told me when I first called him and about the specific way he had approached the situation. He had been my father's attorney for 8 years. He had prepared the will and had done the annual reviews, and he had known my father the way an attorney knows a long-term estate planning client, which is to say not as a close friend, but as someone whose intentions and habits and specific relationship to his own estate had been the subject of multiple careful conversations over years. When I told him about Devon's call and about the deed, he was quiet for a moment. Then he said, "Your father did not tell me about any deed." He said the last time he had seen my father at the will review meeting, my father had confirmed the house to me. He said he found it very difficult to believe that my father had transferred the house 2 months before that meeting and had then sat with him and confirmed a will, leaving it to me without mentioning the transfer. He said that was not consistent with how my father had operated in their 8 years of working together. He said my father had always been explicit about his intentions and had never failed to mention something significant that bore on the will. He said I should look at the notary. He said notary commission dates were public. He said it was the first thing to check. He had been right. I checked. The commission was expired. Charles had known what to look for. He had pointed me directly at the answer, that the deed reflected Walter's genuine intention and that any technical defect in the acknowledgment should not override my father's expressed wish to give Devon the property. Josephine's reply was direct. She said the argument about intent was not a legal basis for validating a deed with an invalid acknowledgment. She said Ohio property law required specific formal execution requirements because those requirements existed to protect property owners and to ensure the reliability of recorded instruments. She said, moreover, the intent argument was undermined by the fact that my father had reviewed and confirmed his will as current at approximately the same time the deed was purportedly executed, and that will left the property to me. If my father had genuinely wished to change his intention, he had been meeting with his attorney at exactly that time and had had every opportunity to do so through a valid instrument. The Lucas County Common Pleas Court. I want to explain something about why the substantial compliance argument Devon attorney had made did not work and about what substantial compliance means in the context of deed execution. Ohio courts have recognized in some contexts that minor or technical defects in deed execution can be cured by the doctrine of substantial compliance, which holds that if the grantor substantially complied with the execution requirements, the deed should be given effect. However, courts have consistently held that the substantial compliance doctrine does not apply where the acknowledging officer lacked the authority to perform the acknowledgment. The commission requirement is not a technical formality like a missing witness signature that can be excused if the execution was otherwise observed. The commission requirement is a substantive qualification for the person performing the act. An unqualified person cannot perform a notarial act at all. A person whose commission has expired is not a notary. You cannot substantially comply with the requirement that the acknowledging officer be qualified by using someone who is not qualified. The qualification was absent. The act was therefore not performed in any legal sense regardless of what the document looked like on its face. Judge Osei had applied this distinction correctly. Josephine had briefed it clearly. The doctrine the defense had relied on did not apply to the facts they were defending. The commission requirement was substantive. Substantive requirements do not yield to substantial compliance. I also want to explain something about the significance of the will review to the overall picture and about why Josephine had included it in the filing, even though the defective acknowledgment was sufficient to void the deed on its own. Courts that hear property disputes involving alleged transfers to family members are attentive to the full factual record. A deed with a defective acknowledgment can be voided on that basis alone without any additional context. But presenting the will review and its timeline served a purpose beyond the strict legal argument. It showed that the legal outcome was consistent with the decedent's expressed intentions as documented through a formal instrument with a proper attorney and proper execution. The voiding of the defective deed was not overriding my father's wishes. It was giving effect to his wishes as documented through the properly executed instrument, which was the will. Josephine said judges in contested estate and property matters appreciate when the legal outcome aligns with what the evidence shows the decedent had actually wanted. The evidence showed my father had wanted the house to come to me. The will said so. The will review 2 months after the deed said so. Charles Park's account of the meeting said so. The legal outcome of voiding the defective deed and giving effect to the will was the outcome that honored what my father had formally and deliberately documented. The defective deed did not represent what he had documented. The will did. The court honored the will, assigned the matter to Judge Emeka Osei, who had been handling civil matters in Lucas County for 8 years. He reviewed the submissions. He asked Devon attorney at the hearing to explain the legal authority for the position that a court could overlook a defective acknowledgment on the basis of the grantor intent. The attorney cited cases involving substantial compliance with execution requirements. Josephine responded that the substantial compliance doctrine did not apply where the acknowledging officer had not held a valid commission, because the commission requirement was a substantive qualification, not a technical formality. Judge Osei said he had reviewed the applicable law and found Josephine analysis correct. He said Ohio law required that acknowledgments be performed by qualified officers and that a person without a valid commission was not a qualified officer. He voided the recording. He quieted title in me as the beneficiary under the will. He referred the matter to the Lucas County prosecutor for further review. The estate was administered under the will. The house on Geneva Avenue came to me. I drive to Toledo 3 or 4 times a year, and I spend time in it, and I work on the garden my father had kept on the east side of the lot. The garden was his project, and I am learning it the way you learn something someone else built. By paying attention and by being patient. I want to say something before I go. I want to say something about what the specific experience of the hearing before Judge Emeka Osei was like and about the question he had asked. I had been in court before for professional reasons, depositions and proceedings related to clinical cases, and I had the professional's ability to be present in a formal setting without being overwhelmed by it. Josephine had prepared me for what to expect. She had said the judge would have reviewed the submissions and would ask Devon attorney to identify the legal basis for the position that an expired commission could support a valid acknowledgment. She had said there was no such basis and that the attorney would know this and that the hearing would be short. She had been right about all 3 predictions. Judge Osei had the deed and the Secretary of State printout on his bench. He asked the question about the legal authority. Devon attorney cited the substantial compliance doctrine. Josephine responded with the distinction she had briefed. Judge Osei said he found the distinction correct and that the commission requirement was substantive. He said there was no authority for the position that substantial compliance could cure an acknowledgment performed by someone who was not a notary. He voided the deed. He quieted title. He referred the matter for further review. The hearing lasted about 15 minutes. Josephine had said it would be short. The legal question was not complex. The facts were not contested. The 2 databases had been the case. The court had confirmed it. That is what happens when the evidence is clear and the law is settled. I also want to say something about the specific way Josephine had framed the legal analysis to Judge Osei and about why clarity in the initial filing mattered so much. She had opened the petition with the 2 facts that controlled the outcome: the acknowledgment date on the deed and the commission expiration date from the Secretary of State database. She had presented them in the first paragraph of the legal analysis section. She had said, the acknowledgment was performed on this date. The acknowledging officer's commission had expired on this earlier date. These two dates established that the acknowledgment was performed by a person who was not a commissioned notary in Ohio. Everything that followed was the legal analysis of why this fact required voiding the deed. The clarity of the presentation meant that Judge Osei had arrived at the hearing already knowing the core fact and the core legal issue. He was not being persuaded in the hearing. He was confirming a conclusion he had already reached. Devon attorney had known this when the hearing began. The substantial compliance argument had been the best available option from a weak position. It had not been strong enough. Josephine had briefed the distinction between substantive and technical requirements so clearly that the judge had been able to address it directly and definitively. The clarity of the filing had produced the clarity of the ruling. Good legal work at the filing stage determines the shape of the hearing. Josephine had done good legal work. The hearing had taken 15 minutes. The ruling had confirmed the analysis. The house was mine from that moment, not about Devon and not about the prosecutor office. About why the Ohio Secretary of State Notary Commission database is one of the most useful public records available to anyone examining a deed. Every notary commission in Ohio is issued by the Ohio Secretary of State and is recorded in the public database. The database shows the notary name, their county, and the dates of their commission. It is publicly accessible on the Ohio Secretary of State website, and it can be searched by name at no cost and without an account. When you are looking at a deed and you want to verify the notary, you search the notary name in the database, you find the commission dates, and you compare those dates to the date of the acknowledgment. If the acknowledgment date falls outside the commission period, the notary was not commissioned on that date. If the notary was not commissioned on that date, the acknowledgment is defective. If the acknowledgment is defective, the deed is not properly executed. The entire verification takes less than 5 minutes. Use it. Thank you for staying until the end. If this story made you feel something, I also want to describe the specific sequence of actions I took the evening I found the commission expiration and what those actions show about what anyone in a similar situation should do. After I searched the Secretary of State database and found the commission dates, I did 3 things. First, I took screenshots of the deed acknowledgement section from the Lucas County Recorder's portal showing the notary name, the acknowledgement date, and the commission number shown on the deed. Second, I took a screenshot of the Secretary of State database results for Harold Fenwick showing his commission start date and expiration date. Third, I sent both screenshots to Josephine's email with a message asking whether I had understood correctly what I was looking at. She had called me the next morning and confirmed that I had. The 3 actions had taken about 10 minutes. Screenshots are good documentation, but they are not certified records. For the court filing, Josephine had obtained printouts from both systems with the relevant data clearly visible and had submitted them with appropriate certification that they were accurate representations of the public records. But the screenshots had been enough to establish the core fact and to communicate it to an attorney who could confirm it and advise on next steps. Find the notary name, search the database, screenshot both, send to an attorney. That is the process. It takes about 15 minutes total. The result can resolve a property dispute. I also want to say something about what I tell patients when I'm reviewing records and about the parallel to reading public property records. In clinical practice, when I am reviewing a new patient's records, I tell them, I'm going to read all of this from the beginning because I cannot know which piece of information is going to be relevant until I have seen all of them. The relevant piece is often not the one you would have predicted. Sometimes it is something that was noted years ago and that has been in the record ever since and that bears on the current situation in a way that no one connected until it was reviewed. The notary commission expiration date was that kind of piece of information. It was in 2 public records. It had been in both records since the moment it was true. The commission had expired and the Secretary of State database had showed that expiration from day 1. The deed had been recorded and the acknowledgement date had been in the recorder's index from day 1. Both records had been publicly accessible every day between the recording and my search. Anyone with internet access could have found both records and compared the dates at any point in the 23 months between the deed's recording and my father's death. I found them the evening Devon called. The records had been waiting for someone to look. I looked. The comparison took less than 5 minutes. Clinical habit. Public records. 5 minutes. Property protected. The house came to me. My father's intention was confirmed. Everything he had documented correctly was honored. Everything he had not signed was void. The record made the distinction. It always does. Write it in the comments. I read every single one. And if you want to hear the story of a man whose brother had recorded a deed to their late mother house that described a parcel number belonging to a different property entirely, and what the county auditor parcel map showed about which property had and had not been transferred, it is waiting for you in the description below. Click it. Until next time, take care of yourselves, and if someone presents a deed to a property you believe should be yours, look at the acknowledgment section. Find the notary name and the date of the acknowledgment. Search the Ohio Secretary of State Notary Commission database. Compare the commission dates to the acknowledgment date. If the commission had expired before the acknowledgment was signed, the acknowledgment is defective. A deed with a defective acknowledgment is not a valid conveyance under Ohio law. The Secretary of State database holds the commission dates. The recorder holds the deed. Both records are public. Both are searchable. The two dates are the case. I want to tell you more about Toledo and about the house on Geneva Avenue and about my father and what the house had meant to him and to us. Toledo is in Lucas County in northwest Ohio on the western edge of Lake Erie, and it is a city with the particular character of a mid-sized Great Lakes industrial city that has navigated the transitions of the last several decades with the resilience of communities that were built around demanding work and that have found ways to maintain their character through those transitions. Geneva Avenue is on the south side of the city in a neighborhood of post-war brick ranch houses and modest frame houses where the lots are generous and the trees that were planted when the houses were built are now mature enough to arch over the street, and where the neighbors have known each other for long enough that the knowledge is specific and deep. My father was named Walter, and he had I want to describe what the Lucas County Recorder's portal shows when you search a property and find a deed and what the acknowledgment section looks like in the document viewer. The portal is publicly accessible and allows you to search by owner name or parcel number and returns a list of recorded instruments with the most recent first. When you click on an instrument entry, the document opens in a viewer. Deeds typically run from 1 to several pages depending on the complexity of the property description. The acknowledgment section appears near the end of the deed, after the signature of the grantor. It is a block of text that begins with language like "before me," the undersigned notary public, and continues with a certification that the grantor appeared and acknowledged the signing. At the bottom of the acknowledgment is the notary's signature, their printed name, the date of the acknowledgment, their commission number, and their commission expiration date. This last element is important. Ohio notaries are required to include their commission expiration date in acknowledgments. The expiration date on the acknowledgment and the commission expiration date in the Secretary of State database should match. If they do not match, or if the date shown in the Secretary of State database for the commission end is earlier than the acknowledgment date, the acknowledgment was performed after the commission had ended. The deed showed an expiration date that was different from what the Secretary of State database showed. The database was the authoritative record. The database showed the commission had ended. The acknowledgment was defective. The case was in those two dates, solely and entirely. I also want to say something about how the Lucas County Auditor's property search and the Lucas County Recorder's deed search work together, and why starting with the auditor is often the easiest entry point. The auditor's property search is the simpler of the two portals. You can search by owner name or by address, and it returns the property record, including the parcel number, the current owner of record, the assessed value, and the tax history. The parcel number is the key that unlocks the recorder search. Once you have the parcel number from the auditor, you go to the recorder's portal and search by parcel number. This returns the complete instrument history for the property, every deed, mortgage, lien, easement, and other recorded instrument from the first filing to the most recent. I had started with the auditor because I knew the address but not the parcel number. The auditor gave me the parcel number. The recorder gave me the deed history. The deed history showed the most recent deed. The most recent deed had the acknowledgment section. The acknowledgment section had the notary name and date. The notary name went into the Secretary of State database. The database showed the commission dates. The commission date showed the expiration. The expiration was before the acknowledgment date. The chain of 5 searches had taken about 20 minutes in total. Each step led to the next. The answer was at the end of the chain. The chain was made entirely of public records that are freely accessible. Anyone can follow it. Anyone should follow it when the question of a deed's validity arises. moved to Toledo in his late 20s, and had been in the house on Geneva Avenue for 19 years when he died. He had worked for the city in the water department for 26 years, which meant he knew more about Toledo's infrastructure than most people, and which gave him the specific civic identification of someone whose working life had been bound up with the functioning of the place where he lived. He had retired 6 years before his death and had occupied his retirement with the house and the garden and the same neighbors he had known for 2 decades, and with me and my family when we visited, which was often, because Toledo was where I had grown up and where I came back regularly and where my father had the house that was the anchor of our particular piece of the family. Devon is my stepbrother. He had come into the family when our parents married, and he and I had grown up together in the same house on Geneva Avenue. And we had been something like siblings in the years when the family was whole, and after the family was not whole anymore, we had remained in contact in the way of people who share a history without sharing the specific current of daily life. Devon had moved back to Toledo when my father was in his 60s and had been living in the house with him for about 4 years before my father died. This is the context in which Devon had told me my father had given him the house because he had been the one there taking care of things. That part was true. Devon had been there and had been providing care. What was not true was that the deed was valid. I want to describe what a notary acknowledgment is and why it is required for a deed in Ohio and why its validity matters so much. When a deed is executed in Ohio, the grantor must sign the deed and the signature must be acknowledged before a notary public. The acknowledgment is a formal certification by the notary that the grantor appeared before them, was identified, and acknowledged that they had signed the deed as their voluntary act. The acknowledgment serves several purposes. It verifies the identity of the grantor. It confirms that the signing was voluntary and not coerced. I want to say something about the garden and about what it means to have inherited a house that was my father's work for 19 years. He had been a careful gardener, and the east side of the lot had been his project since he moved in. He had built raised beds and planted them with the kind of attention that a person brings to something they intend to maintain for a long time. The beds had the specific order of a garden that has been tended consistently, and that reflects a clear vision of what it should be. He had grown tomatoes and peppers and 3 varieties of squash every summer, and he had brought the surplus to neighbors and to the church potlucks, and had been known on his block for the quality of what came out of those beds. When I drive to Toledo 3 or 4 times a year, I spend time in the garden. I plant what he planted because I know what those beds can produce, and because planting them the way he planted them is a form of continuing something he built. The neighbors still come by in the summer when the tomatoes are ready. The garden is one of the reasons they do. He built it. The deed he wanted to make was the will he had reviewed with Charles. The will said what he had built was mine. The court confirmed it. The garden is still producing. That is what proper documentation does. It delivers what was built to the person it was built for. The record kept his intention. The record delivered it. I also want to say something about what I do every time I am in Toledo and in that house and in that garden. I walk the beds first. I look at what is growing and what needs attention, and I try to see what my father saw when he walked the same beds. He had kept a small notebook in the shed where he had noted what he had planted and when and what had worked and what had not. I found the notebook in the first spring after I had the house, and I use it every season. The entries are in his handwriting, and they are specific. Tomatoes started indoors March 15th, transplanted after last frost. The back 3 beds full sun all day. The front bed gets shade after 3 use for lettuce. 19 years of entries. The first entries are from when I was in my mid-20s, and the last entries are from the summer before he died. I read them the way I read the deed. From the beginning, in order, carefully, because the information in them is the record of what he knew and intended and built. Primary sources. He had left the notebook in the shed because that was where it belonged, and because whoever came into that garden after him would find it there. I found it. I use it. The garden is still producing. The house is mine because he documented his intention correctly in his will, and because I read the deed carefully enough to find the defect. The notebook is one more document he kept correctly and left in the right place. I am the beneficiary of all of his records, and it provides a dated and certified record of when the signing occurred. Ohio Revised Code 5301.01 requires that deeds be executed in the presence of 2 witnesses and acknowledged before a notary or other authorized officer. Without a valid acknowledgment, a deed is not properly executed and cannot be recorded and given legal effect as a conveyance of real property. The requirement that the acknowledging officer be a commissioned notary is not a technicality. It is a substantive requirement of the statute. Ohio notary commissions are issued by the Ohio Secretary of State and are recorded in the Secretary of State's public database. Each commission has a start date and an expiration date, and a notary is only authorized to perform notarial acts, including deed acknowledgments, during the period when their commission is active. A person who attempts to perform a notarial act after their commission has expired is not acting as a notary public because they are not a notary public. Their certification has no legal validity. The acknowledgment they perform is defective. Harold Fenwick's commission had expired 18 months before he signed the acknowledgment on my father's deed. On the date the deed was acknowledged, Harold Fenwick had not been a commissioned notary in Ohio for a year and a half. The acknowledgment he had placed on the deed was not a valid notarial acknowledgment because he had not been a notary. The deed was not properly executed. The recording of the deed did not cure the execution defect. The instrument that Devon had presented as a valid conveyance of my father's property was, from the date it was signed, defective at its foundation. I want to say something about the attorney I called and about what her experience in Toledo property law had given her. Josephine Adeyemi had been practicing in Lucas County for 11 years when I called her, and she had handled cases involving defective deed execution before. She understood what I want to end with something about the professional habit that had protected this estate and about what it means that a clinical skill turned out to be a property law skill. 17 years of clinical practice had given me one core discipline: read the document. All of it. From the beginning. Do not skip sections. Do not assume you know what it says before you have read it. Verify what you find. Look up what you do not know. Do not stop until you understand what the record shows. I had applied this discipline to the deed the same evening Devon called, and I had found the answer within the hour. The answer had been in the public record the whole time. The commission expiration date was in the Secretary of State database. The acknowledgment date was on the deed. The comparison was simple. The conclusion was immediate. What the situation required was not expertise in property law. It required the habit of reading carefully and verifying what you find. This is not a specialized skill. It is a general skill. It applies to clinical records, and it applies to deeds, and it applies to any document where the specific words matter and where the answer is in the record for anyone who reads it. My father had built a garden and kept a house for 19 years. He had also written a will and reviewed it and kept it current. The house came to me because he had documented his intention correctly and because I had read the document that contradicted it carefully enough to find the defect. The primary source said what it said. I had read it. That was enough. I also want to say something about what reading primary sources has meant to me as a history teacher and why the habit transfers so directly to property records. Wait, I realize I should clarify. I am a nurse practitioner, not history teacher. The professional habit I described is the clinical habit of reading records carefully, but the general principle is the same regardless of the field. The primary source document is the evidence. The deed was the primary source document. The Secretary of State database was the authoritative record for the commission dates. The two documents together were the case. I had read both and compared them and found the discrepancy. The discrepancy was the evidence. The evidence was in the records. The records were public. The records were free to access. The records had been there since the day they were created. I had read them on the evening Devon called. The house is mine. My father intended this. The will said so. The deed was void. The Notary Commission database confirmed it. The court confirmed the database. The house came to me. His garden is still growing. The record held his intention. It always holds what was properly documented. Document things properly. Keep the records. Read them when you need them. The answer is in there. There is one more thing I want to say about my father and about what the garden notebook represents to me now. Every entry he made was a form of communication with whoever would come after him in that garden. He had not known it would be me. He had kept the notebook because keeping a record was how he operated. 26 years in the city water department had given him the specific relationship to documentation that infrastructure work requires. You record what you did so that whoever comes after you knows what was done and when and why. This principle applies to municipal water systems, and it applies to garden beds, and it applies to wills, and it applies to property records. He had kept the notebook, and he had kept the will current, and he had kept his files in order, and he had done all of this with the same consistent attention that had characterized his work for 26 years. The defective deed had not been his work. His work was the will and the notebook and the files he kept in the second bedroom. All of that was his. All of that was correct. All of that was there when I needed it. The defective deed was voided. His work stands. The house is mine. The garden is producing. The record he kept is the record I follow. I intend to keep it as carefully as he did. It deserves that much. He built it that way. And one final thought. My father had 19 years in that house, and the house had the character that 19 years of consistent care gives a house. The neighbors had known him. The street had known him. The raised beds were his design and his construction, and his decades of amendment and attention. When I am in that house, I am in the evidence of his life and of what he made. The deed he signed and the will he maintained were both expressions of what he intended to leave behind. The will was properly executed. The will governed. The house came to me because he had done that right, and because I had read the deed that contradicted it carefully enough to find that it was defective. Both things were necessary. He had done his part. I had done mine. The court confirmed both. The records held both. The records always hold what was done correctly. His records were done correctly. I keep them now. I intend to. Had found when I described it, and she understood why it resolved the case. She said the commission was the foundation of the acknowledgment. She said if the foundation was gone, the acknowledgment was gone. She said if the acknowledgment was gone, the deed was not validly executed. She said a deed not validly executed cannot convey title. She said this was not ambiguous law. She said it was the settled application of requirements that had been part of Ohio property law for a long time. She said we would file to void the deed and to quiet title in me as the beneficiary under my father's will. She said we would also submit the timing relationship between the deed and the will review to the court because it was relevant to the credibility of the intent argument Devon's attorney would inevitably make. She said I should obtain the certified death certificate and she would prepare the filings. I want to say something about the will review meeting and about what it showed about my father's actual state of mind at the time the deed was supposedly executed. My father had met with his estate attorney Charles Park to review his will approximately 2 months after the date on the defective deed. This review had produced no changes to the will. The will left the house to me. Charles had told me that my father had reviewed the entire will with him at that meeting and had confirmed that it reflected his current wishes and had expressed no desire to make any changes. He had said that, as of the review meeting, everything was as he wanted it. The deed purporting to give the house to Devon was dated 2 months before that meeting. If my father had genuinely decided to give Devon the house 2 months before, he had then met with his attorney and reviewed a will leaving the house to me and had made no changes. These two facts do not fit together easily. The defective acknowledgment made this inconsistency irrelevant to the legal outcome, but the inconsistency was relevant to the credibility of Devon's position, and Josephine had included it in the filing for exactly that reason. I want to say something about what Devon had said to me at the hearing and about what I believe about the deed and about what I think had happened. We did not speak before the hearing. I arrived with Josephine. Devon arrived with his attorney. We sat on opposite sides of the courtroom. After the hearing, in the hallway outside the courtroom, Devon had stopped and said she would have wanted me to have it. He said she, meaning my grandmother, but he meant my father. He said Dad would have wanted me to have it. I said I know he had a will. I said the will said what he wanted. Devon had not replied. He had walked away. I think Devon had believed, or had been told, that the deed was a valid way to transfer the property outside of the will. I think he may have arranged the deed with someone who had told him it would work and that the expiration of the notary's commission had not been known to him at the time. I cannot say whether the fraud was in the arrangement of the defective deed or in the execution of it. I can say that the defective acknowledgment had been in the public record from the day it was recorded and that the commission dates of the notary had been in the Secretary of State's database from the day the commission expired. Both records had been there the whole time. I had checked both records in the same evening. The comparison had taken less than 5 minutes. The case had been determined by 5 minutes of searching public records that anyone could access for free. I had accessed them. The case had been resolved. I also want to say something about what it meant to me as a nurse practitioner to be the person who found this. My professional life involves reading records with care, checking what documents say against what people claim, and verifying that the information I am relying on to make decisions is accurate and complete. These are clinical habits, and they are also, as it turned out, the habits required to protect a property interest in this situation. I read the deed the way I read a medical record, from the beginning, in order, looking for anything that needed to be verified. I found the acknowledgment section. I noted the notary name and the date. I went to the Secretary of State's database and I looked up the commission. The commission dates were there, the comparison took seconds, the conclusion was immediate. The professional habit of reading documents carefully and verifying what they contain had protected my father's estate. I have applied this habit in clinical settings for 17 years. It applied just as well to a county recorder's deed. Read the document. Read all of it. Verify what it says. The answer is in there if you look for it.